Good evening, everyone, and welcome to the December 19th edition of Beyond the Data. Today we have again with us two attorneys, Mitch Marcheski from Zanesville and Warner Mendenhall from Akron. And we'll be talking about local cases that both of them have been working on and how they've been going, as well as that OSHA reversal that many of us heard about late on Friday. But before we get to all of that, if you like what you are going to hear tonight, you can get to see all of us, all three of us in person, along with Dr. Elizabeth LaFay, who is, of course, absolutely fantastic. And I probably should have her on next Friday. I hope. But yeah, so this is going to be in Summit County, I believe so. And all of us will be there. So if you want to come see us, this will be January 22nd. And all proceeds to this will be going to funding these two and their court cases that they're doing, fighting for us. So without further ado, I'd like to pass it to you guys and start telling us about what's going on in your current cases. People really want to know. So, Warner?
Well, we have quite a bit going on. Let's start with some of the older cases. One of our first cases was a business shutdown case involving Untitled Tavern here in Akron, Ohio. And that one, we believe we're going to file a memorandum on jurisdiction with the Ohio Supreme Court. We think that the Liquor Control Commission went outside of the scope of its power in shutting businesses down that were serving liquor within the timeframes of their liquor license, but outside of the timeframes that the Liquor Control Commission arbitrarily set to deal with the pandemic. The next case is the Miami University case. I think some people have been following that one. The school basically did not require, for the unvaccinated folks who had sued, did not require the weekly testing, masking, and some of the other stuff. And the judge said, well, then in that case, there's no issue, there's no standing to continue. But we believe that those types of rules and regulations could reemerge at any time, and that it could be repeated. And if a situation can be repeated, then we have a right to get a ruling on it. So that appeal will involve that issue. We have also got a case pending against Ohio University, which Tom Connors is handling here in the office. That case is active. We have a case against University of Cincinnati. That case is active. These are active in the Common Pleas Court. On the University of Cincinnati case, the judge set a hearing pretty far off in the future in March. But we are going to be requesting after the start of the year that they have an injunction hearing as quickly as possible, because the students and faculty are certainly at risk of all the requirements there. So I'm very hopeful we can get a hearing. This case would be before the start of the semester. We also have a case against the against the companies down at the Portsmouth Gaseous Diffusion Plant, which is a nuclear facility in southern Ohio. And it's interesting what happened there. Most of the companies actually kind of backed down, and we believe that salvaged approximately 170 jobs, but 20 people are still at risk. And we have some briefing due on that coming up on December 27th. Another case that we have pending is the case against Smuckers. As people know, this is a private employer. They happen to have some federal contracts. They also arguably could be under the OSHA mandate, which the Sixth Circuit, I'll get to that in a minute, which the Sixth Circuit removed the stay from. So the OSHA mandate technically is alive again. But we are set for hearing on that one Tuesday morning. And then we have a number of cases in development, and I think your audience is aware of these, but we are currently turning attention to the school systems the masking, and I think most parents are just horrified at the possibility that children could be mandated to have a vaccination. So I think in terms of the parents and why they're moving on it so quickly is I think they want to get the principles established on the masking issue and the quarantine issue before other issues come up. So we're looking forward to those cases. All of this makes for a very busy practice in this area of law. And I got to say to people, we have heard from so many people, and I've got, cases we're working on, and we're trying to get everything filed and moving in the timeframes that, I've promised to people. We're trying to keep our promises with that. But we do have things come up, like we have unexpected hearings that the courts are scheduling, and we've got to respond to those. So we're trying to be flexible as we can be and try to get all the work pumped out of here as we can. And I do want people to, know, and I want to acknowledge all the people at this office that are working hard. We have 4 other attorneys besides me. Every last one of them is working on this at some level. They're either filing cases, they're helping advise people on the EOC issues, workplace issues, but there's 5 of us activated working every day on this. So I know I'm kind of the face of the practice, and Tom Connors has been on the show as well, but there's a bunch of people in the background. We also have a union investigator, retired FBI agent investigator, support staff. And I can tell you, the commitment here from everybody has been tremendous. And, I'm basically working 7 days a week. I know Mitch is as well. I think we're probably going to take Christmas off, but I think I'll probably be back in the office right after Christmas. So I think that does it. Mitch, why don't you update on what you're doing? And then if you want, Catherine, I'll come back on and talk a little bit about the Sixth Circuit opinion.
Yeah, I'd like to echo what Warner said. I mean, it's just, overwhelming all the time. I mean, even on the weekends, if I'm in here, the phone rings, the emails are coming in. And all of the situations are very dire, frankly, where there's deadlines, bad things are going to happen unless there's some sort of intervention. I'm a one-man operation with one full-time paralegal, and so I'm quite limited, as you might imagine. I had spent, in 20 years of practice, I had never slept at my office more than one night, and that was few and far between. But the week before last, I was here, slept at my office 4 nights in a row, and then worked till like Sunday or Monday morning till like 3:30 in the morning. So we're doing all we can. There's no shortage of wrongdoing, no shortage of bad actors out there, no shortage of plaintiffs out there, no shortage of good cases, actually. It's just the manpower. You just have to have the manpower to do these things, and you've got to set priorities, which is always difficult to do, because I know each person's case, to them, and as it should be, it's the most important thing going on in their life at that time. What I've been focusing on, and it's tapering off just a little bit, so it's going to allow me to shift my focus, but it's basically helping people keep their job. That's what I've been doing for the last several weeks, especially with the situation at Ohio Health. I probably got 35 clients that I'm retained on for Ohio Health. Thankfully, they have put a pause, as they like to call it, on their enforcement of their policy. And that really was kind of a sudden thing, frankly, because on December 4th, which was a Saturday morning, they sent out hundreds, if not thousands, of emails that they were going to, as I like to call it, drop the hammer on these employees starting Monday morning. I mean, they were giving them a weekend to get vaccinated or else. And so I had emails coming in, and I had 19 people retain me Saturday and Sunday. And so what I did is I sent out demand letters, FedExed overnight. I emailed those to my clients, and then I had my clients email those to 3 people, their immediate supervisor, the HR department, and the special email address that was handling the COVID exemptions. And so you times that, 19 times 3, and this is going on over the weekend. And then many of those people received those emails and said, why am I getting this? And so they then would forward it to whoever. And so by the time Monday morning rolled around, and I know there were other pressures, there were people protesting, there were other letters and phone calls and so forth. But I know that I thank my clients for this. I think they just had a huge effect on what Ohio Health was going to do on Monday. And they just totally changed their plans. And I got a call at about 10:30 or 11 o'clock in the morning from an attorney who was assigned, actually 2 attorneys are assigned to handle just my cases for Ohio Health. And he had mentioned, hey, we're getting a lot of your letters in here. Instead of sending them to all these different people, just send them directly to us. We're going to handle your cases. And so I said, fine, a very short conversation. And then about an hour and a half later, the announcement comes out that from Ohio Health, hey, by the way, guys, this regulatory environment, I'm doing a little play acting here, is just awfully uncertain right now. We've got House Bill 218, we've got the OSHA put on hold, we've got the CMS guidelines put on hold, and we've decided this is not really the best time to do this. So we've decided to put a pause on our actions with regard to this. Well, that was old news. That stuff happened 10 days, 14 days earlier, and it was my clients and many other people from Ohio Health. Congratulations to all you guys for hanging in there and fighting and swinging back. I'm very proud of all of you, by the way, because that's what it's going to take. And you know what? When your enemy's on the run, you keep them on the run. And that's what I intend to do, and that's what my clients intend to do, is you keep them on the run. We're not going to give these people a rest. They're not giving us a rest. They don't care about us. Remember that? Yeah, you remember. They don't care about you, whether you make your car payment, whether your kid stays in band or not. They don't care about you. So we're going to continue the fight, and we're going to keep them on the run. So I'm really proud of my clients, and we got a lot accomplished with Ohio Health. Now we'll see what happens. Obviously, they're regrouping. Do I trust them? No, I don't trust. Not as far as I could throw them, as my mom used to say. No, I don't trust those people. So we're going to keep the pressure on, and we're just going to see what they do, and we'll react to it at the appropriate time. Right now, there's not any real damages per se, because there haven't been any terminations, and I've been assured by their attorneys that there's not going to be any stigmatization or any kind of retaliation, and so far there has not been. So we'll see what happens, but that's the Ohio Health situation there, which it was a very, of course, that was about almost 2 weeks ago when that occurred. So yeah, very pleased how that turned out. Had another matter with a college down on the Ohio River. I'll just give you a hint. It's known for its petroleum engineering program. You can put 2 and 2 together on that one. I had some clients there that were in a physician's assistant program, and they were in their final year, and the school was just playing games with their religious exemptions as usual, claiming that they couldn't place them anywhere. Like, hey, nobody will take you. We just can't find anywhere to place you. And by the way, the accrediting agency has changed their policy where now you have to be vaccinated and you don't get any exemptions, or else we lose our accreditation for the program. Well, had an individual who was helping these 2 clients of mine out, and did a little bit of investigating of their own, and got an email from the accrediting agency saying that that was totally false, that they do allow unvaccinated people, and you could still be, your college can still be accredited for that program and have unvaccinated people. And then this person also did some excellent follow-up with some of the medical facilities, and he found 4 of them that were more than happy, just thrilled to have students. We're just wanting to have them. Just couldn't wait to get them in there. And to be honest with you, these people were just lying to my clients. Yeah, you heard that right. They were just lying to them, period, flat out lying to them. And so I sent about probably that memo with all those stacks in there probably ended up being, this is single space, probably about 13 pages. And we basically, as my dad used to say, we don't use this term anymore, but we read the riot act to them. And within about 3 or 4 days, I get a letter from their attorney saying that they're going to recognize the exemptions and that they can go ahead and get placed on their clinicals. So that was a very happy day. Got that news on Friday. And then there was one other one, a healthcare provider, I think Premier Health outside of Ohio, that was giving my client a very difficult time, denied the exemption. And then I sent a demand letter, and then probably about a week went by and they threw in the towel as well. So these things are winnable if we fight them. It's not going to be easy. They don't want to make it easy. They want you to get discouraged. So all you guys out there just need to hang in there. This is very, very winnable. And I'm in it for the long haul. I've already made up my mind, so I'm not quitting. So as long as you guys are in the ring slugging away, I'll be like that trainer in Rocky, that old guy who kind of wish he was in there in his younger days, like Rocky, swinging away. I'll be in your corner, swinging away at these people because they really need to be put in their place, and they're flat breaking the law here.
Yeah. Oh, I'm kind of echoing. Hold on. Nope. There, it's on. Yeah, I think it's on Warner's this time that we're echoing here. I don't know what's up, but with the clinical situation, actually, that's been now going on for a couple weeks. I actually put a call out on the different social media about that, because that's been one of those things been kind of hidden, where out of nowhere now, people who had exemptions through the fall were now suddenly being told that no, they couldn't go to their clinicals, and it is flat out wrong. That is not true, but it's happening all over the health systems. And yes, so happily, I mean, Carrie Benton, this happened to her daughter, and she is who she is, and she went in and she fought for it, and she's been helping some other kids through it as well. But I mean, this is one of those things where we need to know that this kind of stuff is happening, and the people that it's happening to, that they're not alone, and that we've got to get people together, and we've got to get them talking to each other and how to attack these different things. Because as wonderful as you two are, Warner's got 4 other attorneys, as he said, but that's not enough. We definitely need to start fighting back individuals against the machine here. That was actually one of the questions earlier on this thing as well, is, what can the public do to help support you with these kinds of things? Or what can we do to protect ourselves? I mean, like myself, I have absolutely no experience with the law. I have no idea where even to begin. And they're doing it on purpose. They're doing it to knock us off balance and leave us feeling like we have no way out. And I think they're really going to do it very badly to us in the next couple of weeks, because then we won't even be able to get a hold of a lawyer, because you guys will be taking the vacations that you actually need for your own sanity. So do you guys have any kind of I don't know, what can you tell us in this situation where we know that the avalanche is coming?
Am I live now again or not?
Yes.
I am. Okay. I mean, everybody just needs to take the steps we've talked about before. If for some reason you're fired, you've got to file for your unemployment, fight through that system. If you're experiencing discrimination because you're unvaccinated, file with the Ohio Civil Rights Commission, which is a dual filing. You get filed under Ohio law and federal law if you file with the Ohio Civil Rights Commission. And there's a process by which your employer has to defend their decision making, has to defend, whatever accommodation or lack of accommodation, and they'll have a mediation with you to go over that. And that is a dual filing. By that I mean, if you file with the Ohio Civil Rights Commission, it's dual filed with the Equal Employment Opportunity Commission. And ultimately, if the mediation, or they call it conciliation, fails, you do get a right to sue letter where you have a right to go to a federal court and sue them. I mean, it's a tough process. It's a long process. But I mean, unfortunately, I think we're going to have thousands of people. We already have thousands of people who I believe have been discriminated against. And, we need to let our agencies know that, and we need to get that process started. The employer will be forced to prepare files and defend their decision making and spend time, energy, money on it. And we need those employers to feel what we have felt. We've been completely overwhelmed as employees, I know, in all these employer requirements. We need to turn it on them a little bit. Force them, if you're experiencing discrimination in your workplace, you need to force them to answer for that discrimination. So, and we're going to try to have, to me, it's not that complicated, but we are going to put up on the website, and Mitch and I will both do that, I imagine, where we'll have sort of a decision tree about what you can do, so that you'll have some guidance anyway without having to talk to an attorney. I mean, we're here for you. We'll try to talk to as many people as possible, but it is physically impossible to answer everybody who's calling us and trying to reach out to us. We do have current clients we're trying to serve, and we've got all kinds of what Mitch termed dire situations that are bubbling up. I do want to talk about a couple of those dire situations, and this is a little bit off the employment side, but I've had 2 calls this week with people trying to get ivermectin administered to their loved ones. And there is just no willingness still on the part of hospitals to be flexible about that. One of the things that happens with that is if you're having an issue like that, try to bring it to attention as early as possible. By the time somebody is unconscious, in an ICU, it's awfully late in the day. And unfortunately, we've had that situation arise. Just as early as possible, I urge everybody, if somebody gets ill, and, I guess we do have this new variant going around, get that early treatment as quickly as you can and start advocating. If a loved one has to go to a hospital, I mean, we need to know right away if we're going to have any chance to do anything on that. So I know that's a little bit off the employment side, but when Mitch mentioned dire situations, a few of them came to mind here for me.
Yeah. Yep. I know there's an attorney out of New York that, and I forget his name offhand, that he did one down in Butler County. And he did one in Virginia, I believe, where he does a lot of those, where he can go in there very quickly and get an order to have that medication administered. But let me address some of the comments that I'm seeing. You guys out there, understand something. Don't get legal advice from your HR department, please. Of course, they're going to tell you can't get unemployment. They're not an objective advisor. So, they said I couldn't get unemployment. They lied to you, like they've lied to you about everything. Please get that through your head. These people are not your friends. Yeah, but I double dated to the prom with them. So what? That was 30 years ago. They're your boss now. Yes, you apply. You go ahead and apply for unemployment because you're going to right away. The burden is on the employer to prove that you were terminated for a just cause. My contention is that asserting your right to a religious exemption, which is your constitutional right, if you get fired for that, that's not a just cause. And of course, that's going to be the basis of your EEOC complaint. So please go ahead and file these things. It doesn't cost you anything to do it. I saw that in the comments as well. It doesn't cost you anything. Yes, it's going to take a while to get your hearing or get your mediation or get your conciliation. Not much can be done about that, but go ahead and get that filed in any event. So yes, especially on the unemployment and these things, these employers are basically making their own dictionary. They're calling things like, on leave without pay. That, to me, that's like a layoff. It's like the auto plant workers, they get laid off. They get unemployment during that time. If you're not getting paid, you need to apply for unemployment and then sort it out later. Don't try to figure it out now. Just get your application in, get your information in, get that process going. Don't second guess yourself on that. Just get it going. If you're wrong, the hearing officer will tell you you're wrong. It's no big deal. So I just thought it would be important to point that out, just looking at some of the comments here of things that you can do without an attorney. Certainly that's one of them.
I can address that. And I see some comments about unemployment in there. You have a right to unemployment unless you're fired for just cause. And there is going to be an argument about whether or not refusing the COVID injection is just cause. And unfortunately, we're going to have to be litigating that issue. I personally don't think firing somebody for not taking a medical procedure I don't see how that can be classed as just cause for firing. So, but that's the basis for that. So if you're not fired for just cause, you're still eligible for unemployment. And we know the employers are going to argue that. And it's just going to have to get hashed out like a lot of this other stuff is being hashed out. I could jump around and answer a couple other quick questions that I've seen come up. Somebody asked about the Ohio University lawsuit. I believe, and Tom is directly filing that, but I believe he has filed for a preliminary injunction against Ohio University. It's the same thing that we're going to file against University of Cincinnati as well, like I said, before the semester starts. So that is moving. And then someone else asked something about despite the fact that, well, DOD, apparently Department of Defense, I think, is denying all religious exemptions. It doesn't matter if they deny it or not. It's still a violation of your right. So you are setting them up for a potential lawsuit. You've set them up for an EEOC complaint. Now, under the rules, you really should try to get your complaint filed in about 180, in less than 180 days on these discrimination statutes. So get it filed either with the OCRC or EEOC within the next 6 months or within 6 months of the adverse action that was taken against you, and get that process moving. And then eventually that does result in the right to file in court. So I think I've covered those three issues.
Let me add something real quick. I saw something about a voluntary resignation. There again, the employer is rewriting the dictionary. Unless you've given a letter of resignation, you've not resigned, and just stick to that. That's just everyday common sense logic there. They might say, if you don't take this, you're voluntarily resigning. Say, well, you can term it whatever you want, but I'm still filing unemployment. I've been terminated. If you even care to have that conversation with them. But in the back of your mind, you have not voluntarily resigned. No, you have not.
I see someone commenting, Mitch, that unemployment is awful. I agree with you. I mean, so many people have had so much trouble with the system, but even though it's awful, and I imagine that our OCRC and EEOC processes are going to get overwhelmed, just like unemployment did, we still have to, we still have to make our filings. We still have to fight for our rights. We still have to fight for the unemployment benefit that you're due. And I know it's awful. We've got to hold, ultimately, I think everybody's getting it. It's not just the courts that are going to save us. We've got to save ourselves. And, the folks at Ohio Health, I mean, we know that over 800 people directly signed up to help support the lawsuit down there. And I think it's that kind of pressure. And I think there were over 400 at Cleveland Clinic, hundreds again at university hospitals, that it all, were pooling resources and coming together, to do something about their employer. So the importance of that cannot be overstated. All of those systems back down, I think, when faced with what is essentially an employee revolt. And on top of that, they've got other stresses coming. It's getting to be cold weather. I don't see how any of these hospitals could have survived, terminating that many employees. And it's
They've already told us. They've told us what they're doing. They're bringing in the National Guard now. Governor DeWine announced that, and also they are bringing in a company that has supposedly somehow bring in healthcare workers from out of state. And there's also been reports, I believe I saw the number, about 2,000 H1b visa holders, from a lot of them from the Philippines and that kind of stuff, I believe for Ohio Health. And I believe the number that I was told was around 2,000 that they're going to start bringing in, which, I mean, people not familiar with the visa situation, H1b visas are a pretty brutal visa. They are visas that are attached to the employer. And if you get fired, you go home, basically. So these are rough ones, and that seems to be their way of dealing with losing that many people. And somebody coming in on an H1B is not going to argue. They're just not, especially if they bring in family members, then they'll lose everything. So I mean, that when I heard that scared me because that's how they can fix the problem of workers not complying.
Yeah, we have documentation of Ohio Health in particular, almost bragging about the fact that they were going to be able to bring in Filipinos to assist, and bragging about the fact that they wouldn't have to pay them traveling nurse salaries, and bragging about the fact that they could be on a 3-year contract and really locked in, to keep their behavior under control. So, I'm glad you brought that up, Catherine, because, that needs to be addressed through our Congress people. We need to call them, let them know about the abuse of the H1B system, let them know how it's displacing American workers, and pressure them to change that system. There's a lot of reform that we need to do. But that's a great one to point out.
Yeah. Maybe I'll cover a little bit on the Sixth Circuit decision.
Sounds good. People are definitely asking from the moment that came down. We've been, what does this mean? Is it back on now? What's going on?
It is. I mean, just real quick, it is, but you still get religious exemptions. So you still can be exempt from vaccination on a religious basis and on a medical basis. So even though you've got this OSHA in place here, it does not negate Title VII of the Civil Rights Act of 1964. Thank goodness for that act. I mean, it's people marched and died and were hit with water cannons to get that passed. They paid a high price, and there was probably 20 years of litigation prior to it, and probably another 10 years of litigation after it. So notwithstanding the OSHA mandate, I mean, in some ways, I don't see how this really, it's not going to change what I do in my office for employees with religious exemptions. I mean, it's just not going to change anything for me. Maybe Warner sees something else there, but I mean, obviously it would be good if the injunction was still in effect, for sure. But
let me address this a little bit, just so we have a little bit of context. What OSHA did was they issued what's called an emergency temporary standard. And by that, they bypassed the normal process for rulemaking, where they propose a rule in the Federal Register and people get a chance to comment. Employers and employees alike can come in and comment on it, and they have a debate about it, and then they finally establish a rule. They also collect information, evidence that backs up the rule. What they did was bypass that entire required mandatory process, saying they had a grave danger, which of course they hadn't addressed for almost 2 years, but they had a grave danger, grave enough to impose this temporary standard. And right now, that standard is to go into place January 10th. Now, the Fifth Circuit Court of Appeals said, look, this is clearly it must not be that grave because you waited this long. And B, this is unprecedented because it doesn't deal with the workplace. It's the occupational, it's the occupational part of this. So the Fifth Circuit Court of Appeals focused on the workplace. The Sixth Circuit focused on the word health, occupational safety and health. So health is what they focused on. But regardless, this is far beyond, the OSHA was set up and given regulatory authority by Congress to deal with workplace issues. And this is clearly beyond that. We had a nice dissent from Judge Larson, who points that out. And she says, the premise of this whole thing is that the COVID injection works. So I was very happy to see a judge, point out that, hey, maybe this thing isn't working, so this has gone. So the decision was made by the Sixth Circuit on Friday evening, I believe. There have already been emergency motions filed with the U.S. Supreme Court. So I do expect that the Supreme Court, is going to make a decision before January 10th, and certainly before February 9th, which is sort of an alternative deadline based on a reasonable attempt to comply. And I also would predict that the Supreme Court is going to overturn this. So the way this works, if anybody cares, is the decision from the Sixth Circuit goes to Justice Kavanaugh, and he's going to decide what happens to it there. He actually, on his own, could reimpose the stay, or he can throw it to the rest of the Supreme Court to make a decision in the meantime. So either way, it's going to the Supreme Court. I'm going to make a prediction right here that it gets overturned because we've never seen anything like this before. And to add to that, like Mitch says, your exemptions in Title VII, they still hold. So make sure you're requesting your religious and medical exemptions. Those are supposed to be respected here, no matter what.
Yeah. I did see a comment about. Oh, go ahead, Catherine.
No, the one thing I wanted to say there with the whole religious exemption thing, I mean, the frustrating thing for us is we know they're breaking the law. They know they're breaking the law. It's just that they don't care. And it's in the real world, real life situation, it's like, yes, they should respect it, but they aren't. And there are definitely financial consequences when they do so. And it's one of those kind of like, yes, but I it's that kind of dark little grain cloud in me again, where it's yes, then what do we do to
Yeah.
stop them?
I see a comment over here that is a good comment that we should clarify. Just so people know, OSHA is not requiring the injection. It's an injection or a test and mask. So its own regulation proposes this alternative. And the question in particular was, can you get a religious exemption from the testing and masking? I believe you can, because you put your request in, and then the employer then has a duty to try to accommodate that objection. And it's through that process, which we have seen kind of short-circuited so far, that the employer has to accommodate your religious exemption. So I hope that's clear. It's not just the injection. It's the injection or test and mask, and you can file a religious exemption for that, definitely.
Yeah. And then I saw a comment about rescinding or revoking an exemption. That's complete nonsense. I've had a couple of those as well. And basically, I just send the same demand letter. You granted it one time. It was good enough for the first time. And I basically demand that they recognize, and that's the word I use, recognize. They're not granting us anything. We already have the exemption. We're notifying them that we have it, and we're asking that they recognize it and provide the reasonable accommodation. It's puzzling as to why they would paint themselves into a corner. And I've seen ones where they've recognized a flu exemption, influenza vaccine, and then the same personal statement of sincerely held religious belief is sent in on the COVID, and they deny that. Same thing there. A demand letter goes out, and they're basically painted into a corner. They've painted themselves into the corner on that.
So that's the thing. I mean, if we've got to somehow multiply exactly those kinds of demand letters beyond just the few of you. We as normal people need to learn how to write the nastygrams, and I'm not a nastygram kind of person. I don't know how to do this. I don't know what little trigger words there are. I mean, anything you guys can, like your tutorials that you gave about those religious exemptions, they were so fantastic because they were exactly that. They helped people like me who don't deal in the law. We don't know how to write or address how you're breaking the law. This is self-evident. Why are you doing this to me? How do you fight back against those kinds of bullies? I don't even comprehend it, let alone be able to make them do what I want them to do. So yeah, I mean, if you guys can help us multiply it, I think that would be something very, very powerful to do.
Yeah, I mean, just to be very frank with you, I mean, I think a lot of it, because I've actually given my demand letter to a few people and they were denied their exemption. It was my demand, but it was their signature, not my signature. So, and so on those, they retained me, and I sent the same demand letter, and I've not received the response quite yet on it. But, it should not be that way. Yeah, I mean, no, these are bad people. They're lawless. They just don't care.
I'm going to respond to a couple of comments that I see coming up, and I'm trying to keep up. There's lots of them. But, somebody said something about religious and medical exemptions don't fit. Remember, it's not just whether you have a religion. It can be an ethical basis. There's lots of basis for that exemption. It doesn't have to be that you're Catholic or anti-abortion or whatever. You can say that you have a reason of conscience that does not relate to any established religion. So I hope people are clear about that. I'm glad the person brought that up. But, it's submit that reason of conscience. That is certainly part of this. There's another comment over here about, I guess some of our cases got some attention on Steve Bannon's War Room and something else. I honestly, I can't keep up with everything that's getting published out there. I appreciate whatever attention can be brought to the cases that have been filed. I'll look for it when we hang up here today, but no, it's hard for us to keep up with the media stuff.
Warner has Warner's War Room. You got your own war room you're trying to manage, and so do I. Yeah. Just a thing on the conscientious thing. As long as it can be a non-theistic religion, as long as it's held with the same passion, conviction, and sincerity as a theistic religion, and it goes to things of right and wrong, good and bad, morality and ethics. So I've had clients that had non-theistic beliefs that were as strong, maybe stronger, to be frank with you, I mean, than even people that had theistic beliefs, where they would have a guilty conscience if they didn't eat the cleanest food and the most purified water. They would actually feel that they were doing something wrong. That's the kind of thing that the Supreme Court recognizes as a religion, because it goes to the heart of what's right and wrong, and it's very deep, and it's very passionate, and it's very sincere. So yeah, if in your mind it has that status to it, then the courts have recognized, there's several cases on this, including the Supreme Court. And Supreme Court actually said, I think it's a 1989 case, that the Supreme Court is not an arbiter of scriptural interpretation. So if you interpret your religion or scripture in a certain way, assuming it's biblical or Christian or Judeo-Christian, the court is not interested in questioning that. Now, your employers will try to shake you from that. There's no question about it. But the question is your sincerity of that belief, not if it's reasonable, not if it's logical. How sincere is that belief? And I've often done a little bit of play acting. I used to teach, and I would say, if I had to go to court on something like this, I would just stipulate in court. Stipulate means agree. I'd say, Your Honor, we'll just stipulate that my client's religion is very unreasonable and it just makes no sense at all. We'll just stipulate to that right now, Your Honor. And we'll save a couple hours of testimony here. All I am here to show, Your Honor, is that that belief is sincerely held. And as long as I can show that, I'm winning the case.
Are we caught up on the questions over on the side? They're going fast today.
Oh, there's a few more. We're going to have to, yeah.
Even I'm not keeping up on this one.
I do want to point out that we have now heard from several employers that do not want to go along with this. So, I mean, I don't, I know most of us are facing employers who are just going right along with it, but there are several employers, I guess I'm not at liberty to name them. I kind of wish I could, but I'd have to get permission to do it, who've contacted us in terms of how to deal with these federal mandates. And if you know of an employer who is looking for advice, I mean, Mitch and I would be more than happy to help them figure out how to get their employees exempt from it and how to avoid these mandates. And it's really good to see companies. These are generally, small, medium companies that are standing up to this. It seems to be the large healthcare systems, the large corporations that just, hook, line, and sinker are going with it. But there are employers out there. And I think more and more, those employers are going to have some great employees. As people are looking for a place that isn't going to behave in this way, they're going to get some motivated and dedicated employees who understand that employer is looking out for them.
Yeah, as a matter of fact, I got a call from an attorney from a smaller healthcare system, and she had said that they were wanting to grant, they were wanting to recognize the exemptions. And she told me that this was when I was still teaching my course. She said that she preferred the shorter versions of the religious beliefs, and that if they saw anything that was even close to a deeply held belief, they were going to recognize the exemption. And I thanked her, for that. I said, I don't hear that often. I appreciate that very much. I'll pass that along. But Warner is right. There are many decent human beings out there. I mean, unfortunately, Warner and I, people don't call lawyers when life is going well. I mean, we get called. Yeah, I mean, maybe if they win the lottery and they need to know a CPA or what to do with the money or maybe something like that. But I mean, it's usually because life is not going very well. And so we hear about all the bad ones and the people that are giving our clients a hard time. But I was very encouraged to hear that from this particular attorney that worked from this healthcare system. And she even said that they would give them kind of a second bite at the apple, even if they didn't articulate it in such a way that it was clear that they had a religious belief. She said that they were sending them back, asking for clarification and more information. So, kudos to those health systems and other employers who are wanting to do it right.
Well, when you guys get any of these calls, it would be great if you could ask them for permission to, put them on a list here, and we can get that information out to people to know, okay, these are the good guys, and that we can go to them both as employees or customers. to support people who are standing up for us. That would be great if you guys could ask those things, and we can bring it together and we can get it out there for sure.
I think there is already some sites out there, like redballoon.com, I think is one of the ones that is, posting jobs with employers that are not requiring the injection. I know there's already dating sites that are up as well. So dating, employment, every site you can think of, we're shifting into a parallel economy. And we've talked before how there's an airline starting, there's healthcare systems starting. So, we are literally shifting into parallel structures at this point of people who understand the danger of the injection and the illegality and unconstitutionality of what's happening with the mandates.
Yeah, I did see some comments, and this might be slightly off topic and it's a little technical, about Kavanaugh siding with, the side of the court that he wouldn't be expected to side with. A lot of these, you got to be careful what you read into that, because a lot of these are more on procedural type grounds where, like for example, the United States Supreme Court really does not want to be the first court that you file your case in. We would all like to think that our case is such that it deserves, United States Supreme Court attention, like today. And I get that. If I had a case that was similar to my client, I'd feel the same way. But you got to understand, they're just one court. We've got 330 million people in this country, tens of thousands of cases where they file what's called a writ of certiorari to try to even get the case filed, up from the appellate court. And like most of those are denied, just flat out, just because of time constraints. So the United States Supreme Court, the way they do things, among other things, is they want cases to percolate. And that's the word that they use if you read a lot of their opinions. They want the benefit of all the district courts, and not all the district courts, but many of them, and many of the appellate courts that shake out the issues, do a lot of the research, do a lot of the legwork over a period of months or years, which it often takes with these complex issues. They want to make sure that by the time they get it, say 95% of the research has already been done. And then they can weigh in and at that point say, okay, this is how the law is going to be on this particular issue. So us lawyers are not particularly surprised by it. Obviously we hurt for our clients, and our heart is where our clients are as well. And we would like to see these things go to the United States Supreme Court. But it's just the logistics of it. It's just not possible. It just is not possible. Now, everyone does get what's called one appeal of right. So if you go to federal district court, or you even go to common pleas court and state court, you're going to get one appeal as a matter of right, whether it's at state law or federal law. So your case will get reviewed at least one time by an appellate court. Now, whether it goes to the Ohio Supreme Court from there, or the United States Supreme Court, that's a completely different matter. So I just wanted to point that out. And the other thing is, the U.S. Supreme Court is not big on granting injunctions. That is something they just really don't want to step in and do. They like to give great deference to the lower courts below them. And we can argue whether that's right or wrong, good or bad. I get that. That's for another day. But I'm just trying to explain, because I sense the frustration out there. Why is Kavanaugh and Roberts voting this way, and they normally vote with the other block? A lot of times they're not voting on the merits of the case. They're voting on whether to take the case at this time, whether to let the injunction stay in effect, whether to do an injunction themselves. A lot of these things are procedural. And I guarantee you're going to see those votes go the other way once those cases get argued on the merits. You're going to see those votes go the other way, probably in a much more expected fashion. So just a little bit of encouragement out there. Don't read too much into the fact that Kavanaugh or Amy Coney Barrett, like, wait a minute, I thought she was going to vote this way on it. A lot of those are just procedural in nature and saying, look, we're not ready for the case yet. That's kind of often what they're saying.
Yeah, I'm echoing.
Yes. I don't know why. There we go. I did want to ask kind of a random question in here as well. I mean, what are your guys' prediction on the speed that the Supreme Court might be taking up the OSHA thing?
I think I actually already predicted that to some extent. I think
Well, yeah,
that
the time frame.
I think we're going to have a ruling by no later than February 9th and
Okay.
possibly by January 10th. And you know, in terms of what Mitch was saying, you know, this now has been briefed at the Fifth Circuit Court of Appeals and the Sixth Circuit Court of Appeals. There are probably there's so much briefing by people interested in the case that's also been submitted to the courts that you know, I think the Supreme Court is going to take the OSHA case up and is going to come out with a decision. I think OSHA affects 80 million employees. I think that's the number I've seen. So it's a big deal. It's been fully briefed. It's been briefed out of 2 circuits. Those are all reasons why I think they'll take it up and make a decision on it.
And relatively soon too. So that's good.
Soon. And that should help with the guidance, you know, for other, you know, for the CMS and the contractor cases as well. It's going to apply to those cases as well.
Yeah, I think actually Warner used a good term, fully briefed. See, a lot of research has already been done. And so the U.S. Supreme Court, it should not take all that much more arguing and briefing and research, because it's been, like Warner said, that's the perfect term for it. It's been fully briefed by 2 appellate circuits already. And that's very helpful. I mean, that's just very, very helpful for the U.S. Supreme Court to take that kind of a case. And then secondly, because its effect is it's such a wide scope, it affects millions of workers. And so that's another reason as well. So yeah, I'm 100% with what Warner had said on that.
I see somebody saying if we fix 2020, everything is solved. Here's what we need to do. We are going to have to make, in Ohio, I think, some constitutional amendments to make sure that this kind of interference between the employer and the employee relationship can never happen again in this state. You know, it has never happened that an employer has been in a position to mandate a medical procedure with one of their employees. So we need to make sure that can never happen again in this state, and our country for that matter. But we can certainly in Ohio, and I think we're going to try to work on launching this. We can get a constitutional amendment to clarify that is way beyond the bounds of employers. The other thing that I think we need to start thinking about is this issue of our constitutional rights. You know, for the most part, our constitutional rights end when we enter the workplace. You know, you can think them through, but they basically end there. We need to actually think about certain constitutional rights that maybe should not end at the workplace door. And I'll give you one example. There's a federal court decision that does not allow, that says that a local government can block its employees from commenting on something that's going on in that community. And to me, that decision was really wrong-headed, because we need feedback. They're our employees. If I ask a city employee or a township employee what is going on, they ought to be able to answer me honestly. And we need to make sure we've got protections for the whistleblowers, the honest folks that are in all organizations, to have protection here under Ohio law. We have some under the federal law. We have very little under Ohio law right now. So we need to build in whistleblower protections. And we need to, directly address the First Amendment and drive the First Amendment into the workplace.
Yeah. And I know there's probably most people are aware of this, but the HB 248, there's a push to get that on the ballot. And that might be, sometimes, you look back at your life, you get old enough, sometimes things that look like the worst thing that ever happened often turned out to be, in some ways, the best thing. So, it looks like Governor DeWine's not going to sign HB 218, so we're not going to have any legislation or protection. And I get it. Tons of people worked on that, worked on 248, worked on 435, a bunch of bills in there. But at the end of the day, it's very possible that we could end up with something really super good that the entire state got mobilized and passed. And we still don't, the movement is still growing, and there are still people on the sidelines, but as it affects more and more people, they're going to get off the sidelines. And that's a good thing. We often, us human beings, me included, we don't get off the sidelines unless there's a reason, unless it hurts us, it hurts our family, our kids, our job, my husband's job, my wife's job. So in some ways, long term, I am very, very optimistic. The people that I have met in the medical freedom movement have been just outstanding human beings. And I've asked myself, these are the people I should have been hanging out with the whole time. These are like the greatest people in the world. And I just feel something really good is going to come. Some sort of a 248 is going to pass by flying colors. And I don't know. I'm just very, very optimistic for this issue in the long term. There's a lot of battles between now and then, and we're going to have casualties between now and then. I'm going to have more nights at the office between now and then. I know that. But that's fine because I see the light at the end of the tunnel. And I really believe we're going to end up with something really good that's going to be a model for the rest of the country. And by the way, for those who are just wondering, the best law right now is Montana, because it's a 1.5-page bill, and it makes vaccination status a protected class. Warner knows what that means. If you're a protected class, that's just like race, religion, national origin, sex. That's as good as it gets. And Montana has that type of a bill. And perhaps with 248, we would be awfully close to that if we get that on the ballot, get the language approved, and get that passed. So guys, don't give up. I know there's lots of good news we shared with you tonight, some bad news we shared with you tonight, a lot of questions we couldn't answer. Hang in there. Hang in there. We're going to make this happen.
You guys are great. I see Matt has proposed a constitutional amendment on absolute privacy. That is really important. I mean, we should not have our employers inquiring into our healthcare status for any reason, unless it's critical to some workplace function, but this is not. And then the other thing that we got to address, the doctor's decisions about, have been so influenced now. So somehow we've got to free doctors to practice medicine again in the state. No doctor, and we've had problems, Mitch, you probably know this. We have people who need a medical exemption. We can't even get a doctor to write the medical exemption many times. And I know it's been particularly hard at Cleveland Clinic to get Cleveland Clinic doctors to write for other Cleveland Clinic employees. And I mean, I think that's a breach of the fiduciary duty that the doctor has with the patient. And I'm looking into that as an issue, obviously, because I think that these health systems should not be imposing on, not be interfering with the doctor-patient relationship, which is what they've done. They've done it in medication with the remdesivir and the dexamethasone. They've done it with the medical exemption issue. And, they've got some protocols that have been imposed from above that were failures and very quickly seen as failures, yet they're locked into them. We saw it with the ventilation. I mean, the ventilation was really, in many ways, the wrong way to go with a lot of patients. And there are some nurses and doctors that I've spoken to that think the ventilation killed a lot of people. So, I'm very concerned that these protocols that are coming down from above from administrators are not taking into account the immediate need of any of these patients. So,
no, and this is something that's been going on for a while. I mean, you guys are relatively new to this whole situation, but people who have been watching, for instance, specifically the vaccine situation, will have known what's been going on in New York State and California, and particularly California. This whole they've done this before. This is not new. I actually just saw an article just this morning talking about it, where they are threatening licenses, medical licenses, of anybody who steps out of line, and that's exactly what they've done in California. They took away all exemptions except for medical exemptions, and then they ratcheted down what is acceptable as a medical exemption, essentially to, are you dead yet? If you are not dead yet, you are not exempt. And if you, I believe these doctors are only allowed to write like 6 medical exemptions before they get investigated automatically by the medical board. And this is one of those things that I've seen happening, where we see them do it in one place and then they start repeating it in other places. And like I said, I just saw an article this morning talking about the medical boards. Well, we need to crack down on doctors who spread misinformation and things like ivermectin and writing those exemptions and all that. This is, they're going down that route, and they've already had practice doing this. And I mean, that's a whole other ball of wax. That's a scary one, though.
One reason that they don't write them is that that's governed under ADA, and they have to do more for you, and it's harder to fire you. So the medical exemption is under Americans with Disabilities Act, and the definition of an undue hardship means more than a substantial expense or substantial cost. So that makes it really hard to get rid of you if they grant a medical exemption. I've got a couple clients, we're fighting for both, and we're going to see what happens there. I'm almost, I mean, there might be some litigation out of my office on that, you know, as far as, well, you've got to have a specific contraindication, or you've got to have a specific allergy to a specific ingredient that you have to identify ahead of time before you even qualify. I think it's much broader than that. I do have to do some more research on that, but I just think that, at least my argument at this point, unless I see something different in the case law, is that if it causes any kind of injury or discomfort to you, you deserve a medical exemption. That's going to be my argument.
So here's one, while you're kind of in that zone there, I've been getting told of people who have had their medical exemptions rescinded.
Yep. Yeah.
How?
I fight things hard. You already agreed to it. As far as I'm concerned, I'd like to do a jury trial on that one. I'll keep you on the stand all afternoon while you rescinded it.
But then comes the problem. I mean, again, I come back to the practicalities of it. I mean, yes, we are all in the right. They are all breaking the law. But I mean, for that person who's had their medical exemption rescinded, what in the world do they do as a practical matter? I mean, besides try to contact somebody like you.
Yeah, you really do. I mean, I had plenty of work before this came along, so it's really not, you know, lawyers normally bill about 2,000 hours a year or something like that. Those hours are just being substituted with different kinds of hours with different kind of work. So I mean, at some, and what I was recommending toward the end of my seminars, at the last ones that I did 9 of them, is I was trying to encourage people, call the lawyer. Don't make me or Warner your first lawyer to call. Call your, what I call, family lawyer. And I don't mean domestic relations law lawyer, the family lawyer that's done work for the family, your family. They did your will. They did the adoption for your child. They represented you in that real estate transaction that you did when you bought your house. They've just done things for you, you know, for years and years and years. Kind of like the family funeral home, right? Most families use the same funeral home. Most families use the same lawyer. Call your family lawyer and see if they could do it for you. See if they could get involved. They might be waiting for that phone call, frankly. There's no other way to reach these lawyers, to be frank with you. I mean, you know, I can't really send them a letter. You know, there's just the Columbus area has over 8,000 lawyers alone, just in Columbus area. But the people that are having difficulty say, look, you've been my family lawyer for for 30 years, and then you were my dad's lawyer, or your dad was my dad's lawyer, or whatever. Why don't you try to help on this? Because Mitch and this guy named Mitch and Warner are just too busy, and we need more. And they said to call you first. So I can't think of, at the moment, I can't think of any other way to get more lawyers involved in this, to where, I mean, if we could double the number of lawyers, I don't know how many are doing it in Ohio. I'm less than 10. I mean, I can think of one or two real quick right offhand besides Warner. But yeah, call your family lawyer and say, why don't you do this? So it's just a thought, just an idea, because I think you do need a lawyer. I think you need that signature and you need that letterhead to know that you're just doggone serious about this, that you actually hired a lawyer and you're going to take it lying down. You just can't underestimate the power of that. Seriously. I mean, we're dealing with, I call them the vaccine mafia. This is who we're dealing with here. And I don't want to offend Don Vito Corleone in any way when I say that. These people, it's a religion to them. It's a philosophy for them. It's a lifestyle for them. They're not giving it up. They're not giving it up. So that automatically means that we can't give up either. We just can't. So yeah, call your family lawyer, and if they don't want to do it, call me or Warner, and we'll try to work in, see what we can do for you.
Yeah, Mitch, I've been trying to reach out to other attorneys, and we will try to have a Zoom call with a handful of us to compare notes. And I know the same is true with Mitch, because you've shared materials with me. We're sharing our materials with whoever wants them. So if you have a lawyer that would be interested in discussing this, we are trying to duplicate ourselves with other people. And I am happy to see a number of attorneys have stepped up. And like I said, we have we're willing to share everything we got with you. If you've got a lawyer who wants to do something, they don't have to reinvent the wheel. Right. We've been working on it for months, and we can get them up to speed pretty quick, I think.
Yeah. I've given my letters out and my demand letters out to 2 lawyers that I can think of already, and and they, that happy to provide it to them.
Somebody said a list of lawyers. We're trying to do 2 things. We are going to get a website up. I think we bought a domain. I think it's healthfreedomlawyers.com, but it's not up yet. But as soon as that's up, I'll announce it. We'll post it on Beyond the Data. But we're going to try to get a list of all the lawyers we've identified that are willing to take calls. And that is going to grow. Hopefully it'll grow quickly. And then, we're also going to put on that website some of our materials, so that other lawyers can literally plagiarize everything. I mean, the law, there's no issue about plagiarism in the law. It's 99% plagiarism, 1% inspiration, I think, sometimes. But we'll get that up for them to copy away and get it filed. Everything we can, we're going to put up there. So I'll have that website up and announced here after Christmas. That'll be my Christmas gift to the state, I guess.
That'd be great. We need it in a bad way. Yeah.
I know.
All right. So I think we've covered most of the questions. Do you guys have anything else you want to finish out with here? Any last words?
The same thing I say every single time is, and Catherine knows that it's been a bit exhausting over the last few months here as things have accelerated. I mean, we've been doing this for a long time, but the last few months have definitely accelerated, thanks to Catherine.
You're welcome.
But and so I'm going to apologize to anybody I didn't get back to. And we've been backed up. Looking at my email tonight, I got 500 emails. I'm like, I can't even get through it. I've got assistants who are going to be looking at it tomorrow. So I apologize to anybody we've been slow with or haven't been able to get back to. We are trying. The second thing that I would say is, like Mitch. Let's end on that hopeful note that Mitch raised. For one, these are fascinating legal issues to work on. I feel like in some ways I've prepared my whole life for some of this fight. Like everything seems to be coming together. All my skills, all the different things I've learned about government and this type of litigation, it's all being used. So it's gratifying to be able to use what you know and put it to work for people. And we are blessed in a way to have a very interesting and exciting, probably too exciting, but an interesting and exciting task ahead of us. And we could not do that. And we'd have nothing to do if it weren't for all the brave employees and mothers and fathers who are standing up at schools and doctors and nurses who are standing up in hospitals. I mean, we can't do anything unless you guys are willing to fight too. And then I think you've heard, what I've talked about. We need to expand beyond the law. We've got to get into the politics of it, however messy that gets. We've got to be in the politics. We've got to, we're creating our own media, essentially. Catherine has done that here with this, with Beyond the Data, which we greatly appreciate. And we're learning how to construct, essentially, how to rebuild, some of the foundations on which I think our country is based. And obviously, freedom first, everybody. And our rights, the uniqueness of this country is the fact that we have these civil rights, we have these individual rights that the majority cannot crush the minority. The minority has rights. And those are all crucial concepts that are being revived right now. And I think everybody understands that. And then we need to drive these rights into other places. We need to drive them into the place of employment as well. So I want to thank everybody out there. It's a pleasure and to work on these issues, even though it's overwhelming.
Yeah, same here. Hang in there, guys. We're winning these things. Not every single one, but the majority of them, we win them when we fight them. And the only guarantee that you have is that if you don't fight, you're not going to win. That's the money back guarantee for you. But when we fight, our odds go way up. And like Warner, I told this to my wife and daughter even a couple of months ago. I have felt that my whole life and career has built up to, I was in business for 19 years before I became an attorney. I've been an attorney for the last 20 years. I've taught, done a lot of things, raised 4 kids through college. And this is it for me. This is it for me. This is my fight. This is the hill. Either I'm going to succeed and be a victor on, or I'm going to die on this hill with everything I've got. And thank you to the clients that are hanging in there, where you're groping around in the smoke and the mirror and the dust and the noise and not sure where the direction is. Just hang in there, and we're going to get more people on board to help you guys. And thank you for putting your confidence and your trust in us. And thank you for Catherine for providing this forum that we can talk to you guys on a regular basis.
Absolutely. That's why I built the forum, for people like you and others who are who need to get their voices out there. So I think we should call it a night, and we'll have you guys back probably in a couple weeks, I'm guessing. Sound good to you? Yeah,
sounds good. Yep.
All right. So I want to finish with that advert
for you. Yes.
What's that? Oh, some updates. Yes,
we have some good updates for you, right?
Yeah. So to finish with a nice little advertisement, again, if you enjoyed listening to us, you could actually see us all in 3D. So, and remember, all those proceeds go towards funding exactly the cases that both Warner and Mitch were talking about today. So thank you, everybody, for joining us. Hopefully it was informative and you've gotten a little more hopeful, a little more empowered, and we'll see you again later. Good night, everyone.
Good
night.